Can a hospital make a patient sign away the right to sue before receiving medical care? This is the central question in the landmark torts case, Tunkl versus Regents of the University of California. Let's start with the facts. Hugo Tunkl was admitted to the UCLA Medical Center, a charitable research hospital. As a condition of his admission, the hospital required him to sign a document called a release from liability. This clause essentially released the hospital and its employees from any liability for negligence during his treatment. Later, Tunkl sued the hospital for personal injuries, alleging that he suffered as a result of the negligence of 2 physicians. The hospital moved for summary judgment, relying on the signed release. This brought the case to the California Supreme Court. The legal issue was whether an exculpatory clause releasing a hospital from liability for future negligence was enforceable. To decide this, the court had to look at the rule regarding exculpatory clauses and public policy. Generally, parties can contract to shift risk, but such clauses are invalid if they affect the public interest or violate public policy. Justice Toberner outlines several factors. First, the business must be of a type generally thought suitable for public regulation. Second, the party seeking exculpation is performing a service of great importance to the public, often a matter of practical necessity. Third, the party holds themselves out as willing to perform this service for any member of the public. This leads to a decisive advantage in bargaining strength. Fourth, because of this superior power, the party confronts the public with a standardized adhesion contract of exculpation. Finally, the person or property is placed under the control of the seller, subject to the risk of carelessness by the seller or their agents. In applying these factors to Tunkl's case, the court's reasoning focused heavily on the nature of medical services. The court reasoned that medical services are a matter of practical necessity for the public. You cannot easily walk away from a hospital. Because of this, the hospital had a decisive advantage in bargaining power. Mr. Tunkl had no meaningful choice but to sign. When a contract involves such an essential service, the public interest must override the freedom to contract away liability for negligence. The holding was clear. The release was invalid because it violated public policy. The hospital could not insulate itself from liability. So, why does Tunkl matter for your torts class today? It defines the limits of waivers. It distinguishes between private recreational activities, where waivers are often upheld, and essential public services, where they are not. The Tunkl factors are still used by many courts to determine if an exculpatory agreement is against the public interest. Here is a short exam tip. On a torts exam, always analyze the nature of the activity involved in the waiver. Ask, is it an essential public service or a private recreational activity? This distinction is often the key to the analysis. Also, look for unequal bargaining power and whether the patient or consumer had any real choice in the matter. Understanding Tunkl versus Regents helps you navigate the complex intersection of contract law and tort liability. Legal intelligence, powered by AI infrastructure for legal work and legal learning.